Hey guys, this is Ben from Lavocat Law. In this video, I'm going to talk about offer in the context of the formation of contracts. What is an offer? An offer is a definite promise to be bound, provided that certain specified terms in the offer are accepted. The crucial thing in an offer is that there is an intention to be bound. Whether there is intention to be bound, the test is an objective test. From an objective person, a reasonable person looking at the offer, whether he is of the view that the offeror, the person making the offer, intends to be bound by such an offer. Under Singapore law, the offeree must also actually know that the offeror intended to make the offer. In fact, the Singapore courts follow the UK decision, the United Kingdom court decision of Hannah Blumenthal, which decided that the offeree has to have knowledge that the offeror intended to make the offer. It is also very important that the offer be communicated to the offeree, the person to whom the offer is being made. Otherwise, it cannot be accepted if it's not communicated to the offeree. An offer can be terminated at any time before acceptance by communication to the offeree. Okay, the offeror, before the offeree, the person getting the offer, accepts it, the offeror, the person making the offer, can terminate it by communicating, giving notice to the offeror, say, nope, the offer I made is no longer valid, I wish to cancel the offer, you can no longer accept it. The offer can also be terminated by a counter offer by the offeree. That means, for example, you offer to sell your car for 40,000 and the offeree, the buyer, makes a counter offer at 35,000. Therefore, the first offer that you make of 40,000 is deemed to be cancelled because there's a counter offer. However, once it is accepted, the offer cannot be terminated because once an offer is accepted, unqualified, unconditionally accepted, a contract comes into existence. Therefore, if you terminate the offer after acceptance, it will constitute breach of contract. Under the Electronic Transactions Act, electronic records can be used in expressing an offer or acceptance and can also be used for contract formation. So therefore, as I've mentioned previously in one of my other videos, in a lot of corporate communications, there'll be a lot of emails with offer, counter offers and all that. There may be times when one of the parties inadvertently accepts the offer in an email and a contract comes into existence by virtue of the Electronic Transactions Act. Therefore, whenever you're negotiating with another party, always put in the email subject to contract. Now, an offer should be distinguished from an invitation to treat. What is an invitation to treat? An invitation to treat is an attempt to induce or invite offers, okay, rather than an offer itself. For invitation to treat, there is no intention by the person making the intention to be bound by the person making the invitation to treat. For example, goods on display in a shop are not offers. They are merely invitations to treat. So, for example, a TV, okay, with the price $600 stuck to the TV. That is not an offer, it's an invitation to treat. When the customer brings the TV to the cashier, he's making an offer to buy the TV. When the cashier accepts it and takes the credit card or the cash, then there is acceptance. Advertisements are also not offers. They are most of the time, they are merely invitations to treat. The customer, when responding to an advertisement, makes an offer to purchase the goods, which is then accepted by the seller. Tenders are also not offers. because when a person invites a tender to provide goods or services, just because the person provides the lowest quote does not necessarily mean that it would be accepted. There has to be a contract first. A person inviting a tender may not necessarily choose the lowest bidder to the tender because he may want higher quality, better services. So just because the person made the lowest offer does not mean that the contract exists between the person who invited the tender and the service provider. What about quotations? Are quotations offers or invitations to treat? Well, the High Court in this case called Exim and Fintech Industries held that whether a quotation is an offer or invitation to treat depends on whether the quotation can be considered binding on the defendant the moment that the plaintiff issues a purchase order confirming acceptance of the offer. So for example, if an aircon company issues a quotation for 6 units of Daikin model 1234 at $2,000 a unit, this is in a quotation, and the customer issues a purchase order for 6 units of the Daikin aircon model 1234 at $2,000. That is clearly acceptance of the quotation. So there's unqualified, unconditional acceptance of the quotation. So the quotation can be constitute an offer, and once it's accepted, a valid contract comes into, a valid contract arises. So that's all I have to say about offers in this series of formation of contracts. Thanks for watching this video. Please click like and subscribe.